This is a case about sex, lies, and scapegoats. Who's the scapegoat? Jelee Wright, the person who's decided to put his fate in your hands by pleading not guilty. What about sex? This case oozes sex. There were ads on Craigslist for 100 roses to perform sex acts. Melinda Rogers talked about performing sex acts. Melinda Rogers talked to Jelee Wright. She texted him with a promise of sex acts. There's also lies. What lies? There's lies of commission and lies of omission. Melinda Rogers said a sexual assault was committed. That's a lie. I'll get into that one later. Melinda Rogers said she was an escort. That's a lie by omission. She's not an escort. Everyone knows she's not an escort. Walks like a duck, swims like a duck, quacks like a duck. It's a duck. She's a prostitute. She talked about, or Veronica talked about car dates, where, according to Veronica, an escort provides services in the car. Now, what professions, what people would exchange services in the car? Drug dealers or prostitutes? There are no drug dealers. There's no evidence of drug dealers. Melinda Rogers is a prostitute. Now, just because she's a prostitute doesn't mean she can't be the victim of a crime. I'm not suggesting that. But let's take a look at what she says. Freely admits she put an ad on Craigslist to solicit someone for sex. There was communication between her and Jelee. The communication was, here's my address, here's directions, come on down. And he did. She brought him upstairs in her bedroom, where she brought many people upstairs in her bedroom. And you could see from her wastebasket, which was full of condom boxes, which she said, oh, it wasn't clean 2 or 3 days. That's a lot of condom boxes. But she brought him up there, and she said he didn't pay her. And then they went downstairs. Now, there's a couple of ways you can look at this, ladies and gentlemen. Yes, he handcuffed her. Excuse me. He handcuffed her. Now, look at those handcuffs. Sex kitten handcuffs. Sex kitten handcuffs with pink fur. Obviously not department issue. Now, he's charged with impersonating a police officer, and I'll get into that in more detail. But he had a black shirt and sweatpants. Well, maybe that's an undercover cop, she said. Well, if that's what she believes, that's what she believes. But undercover cops would carry a badge. There are strippers at bachelor parties that look more like a policeman than Jelee White did. And Veronica, who said, oh, I've been arrested before, and I forget the exact language for something like this, where's your badge? Because she knew that an undercover cop must have his badge. But he didn't have his badge, and she was suspicious. But maybe she wasn't that suspicious because she called 311, not 911 at first. Then she called 911. Melinda was saying, no, don't take me, don't take me. and they leave. One respect, oh, he's taking her against her will. But as she admitted on the stand, she's performed role-playing for her people, for her clients, for her customers, or let's call it spade, for her jobs. And that's what they do. What kind of role-playing? She said, oh, sometimes she dresses up like a schoolgirl. She could be the bad student. She could be the nasty boss. She could be the grieving defendant who's being taken away by the big bad officer. And then, after he takes her away, if he just performed some services for her, he would let her go. Now, what happened in that van? No one was there but Melinda. Instructions will say, hey, if there's a sexual assault that is being alleged, you don't need any other corroboration. So, the question is, one, did it happen? Two, if it happened, was it consensual? It's saying you can't rape the woman. And what was she willing to do? She was willing to advertise on Craigslist. She was willing to bring strangers into a home with small children, and she was willing to have sex with them on multiple occasions. Now, if something like this happened, and granted she didn't jump out of the van, however, if something like this happened, wouldn't she tell someone that evening? Since she was a victim, said she was sexually assaulted. She talked to the police that night. She never reported. She talked to the doctors. She never reported it. Approximately 2 weeks later, when she was shown a photo lineup by Officer Antonowitz and to the vote, she never reported it. Now, I didn't ask her why. I just said, well, you didn't report it, and she volunteered. Well, I was embarrassed. Let's talk about embarrassed. Different people are embarrassed because of different things. Some people are embarrassed by nudity. Doctors and nurses see nude bodies all the time. They're not embarrassed by nudity. Some people are embarrassed if they pass gas in public. Some people aren't. Now, some people are embarrassed by public speaking. Public speaking is the number 3 fear, after the fear of death and the fear of snakes. Some people wouldn't want to do it. They would stutter. They would be really embarrassed. They wouldn't know how to deal with it. But there's other people, lawyers, politicians, TV personalities. They're not embarrassed. What about Melinda Rogers? What would embarrass her? Didn't embarrass her to advertise on Craigslist. Didn't embarrass her to sell her body. Didn't embarrass her to do car dates. And that didn't embarrass her. But she was embarrassed to report that she was the victim, not the perpetrator. And why is that? Now, Veronica testified when Jelee White was there that he said it was a felony. I knew it wasn't a felony. I've been arrested before. That's not a cop. And no, that's not a cop. How did she know? Because there was no badge. He supposedly was impersonating a police officer. Now, you saw the receipt. He bought the sex kitten cups the day before. Brought the sex kitten cuffs over there and put her in handcuffs and walked out. When they asked, where's your badge? There was no badge. Came down, he put her in the car. They drove away. Now, they didn't drive that far. Her testimony was, I believe it took around 5 minutes, and they pulled off. And then they had a discussion. And according to her, the discussion was, I will uncuff you if you perform oral sex. I asked her how long did it take. She said, about a minute. She also said it took 5 minutes from the time she did the oral sex to come back to the house when saw the police officers. 5 minutes. Does that really make sense? It would take that long? He was sitting in the driver's seat, and she said he didn't move. He was in the driver's seat. He'd have to take his sweatpants down, his underwear down, and then she'd have to perform the act. Now, she's uncuffed at this time. I think everyone would agree she's street smart, street savvy. If that's the case, why didn't she run? She could have unlocked the car door. Obviously, she did it while driving. Why didn't she run? Because either it never happened or it was consensual. And when she went to the doctor, if this happened, why wasn't she examined? Why didn't she say, hey, this is what I had to do. I want you to examine me so you can get his DNA. She didn't say that because it didn't happen. Now, what happened afterwards? She came back. She was taken back to the house. And when she got back to the house, there were police officers. And what did Jelee do? He freaked. He's with the police officers. He turns around and he starts driving away. Now, she's not seatbelted. She's not seatbelted. He's driving recklessly, and she jumps out of the car. Around the corner, the car's smashed. He was driving recklessly, left the scene, and we're not saying it wasn't him. He was identified by Veronica. He was identified by Melinda. The van was in his name. The receipt was found there. We're not saying it wasn't him. But the question is, what happened? What did he do that under the law would be considered a crime? There's a lot of ways to look at lots of things. And in every trial, we have something called facts beyond dispute. What are the facts beyond dispute here? Facts beyond dispute that Jelee White was driving the car, that Jelee White saw the police officer, that Jelee White turned around and fled. The police officers testified there were lights, there were sirens. I believe Melinda testified she heard the sirens. Whether she did or not, I think it's facts beyond dispute that the police had their lights and sirens on, and facts beyond dispute that Jelee White was driving away from the police and didn't stop. So on that count, ladies and gentlemen, you should find him guilty. I'm not going to stand up here, look you in the eye and say, oh no, it didn't happen. It happened. So we'll get rid of that one. Now, the next one that's easy is the impersonating a police officer. Now you'll see in your instructions, it lays out the elements. And one thing about elements, in order for the state to prove that a crime existed, they have to prove each and every element. So if there are 20 elements and the state only proved 19, you must find the defendant guilty of that charge. Now let's talk about the instruction regarding impersonating a police officer. Instruction number 17. And this is only part of it. It says, who, without authority, shall assume any uniform or badge by which such an officer or person is lawfully distinguished. Shall assume. So this doesn't mean, well, maybe assume, might assume, probably assumed, possibly assumed, it's shall assume. So it's like being almost pregnant. Either you are or you aren't. Either you did this, either you assumed a uniform or badge. Those are the two things. Could be both, could be one or the other. A uniform or badge by which such an officer or person is lawfully distinguished. Had a black shirt on. Had sweatpants on. Is that a uniform by which a person is lawfully distinguished? No. Even if he were undercover, there is no way that that would be construed as a uniform, because different people wear different things. Or a badge. As we know from Veronica, there was no badge. So therefore, he is not guilty of impersonating a police officer. I know it sounds logical. Well, wait a minute. He said he was a police officer. He took her out and he put her in handcuffs. Of course he was impersonating a police officer. And logically, that does make sense. However, according to the law that you as jurors swore to uphold whether you agreed with it or not, he is not guilty. There's another instruction that I think is really important. It's instruction number 8. Talks about the credibility or believability of a witness. It should be determined by his manner, or her manner, upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements and the strength or weakness. How credible is Melinda when she told you, I'm an escort? That's what she said. Didn't say I'm a prostitute. When she said, oh, this sexual assault took place. Oh, these weirdos left messages on my phone. How believable is she? And it's up to you to determine her credibility or believability. That's your job. I can't tell you. DA can't tell you. The judge can't tell you. That is your job. Now, the last part of this instruction says, if you believe a witness has lied about any material fact, any, in this case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. And it's up to you. You can say, well, she might have lied about that, but hey, no harm, no foul. Or you may say, well, now wait a minute. She lied about the sexual assault. She lied about being a prostitute. I don't trust what she said. And if it's corroborated by something, that's fine. If it's not corroborated, like what happened in that van around the corner, you can disbelieve her testimony. There's an old Latin saying, which hopefully I'll get it right. It's falsius in unum, falsius in omnibus. And what it is says false in one, false in all. It's another way of talking about this particular instruction. Now, you read an instruction about reasonable doubt. That's the reasonable doubt instruction. It's the state of Nevada. I'm not allowed to comment. I'm not allowed to give you an analogy. It is what it is. But what is a reasonable doubt when you think about it? Now, if there's two, we'll move from reasonable doubt to the burden of proof. Remember I talked about it in jury selection, that the burden is solely on the prosecutor. If I decide not to put on a case, if I believe that through cross-examination that the state has not made its case, has not proven it beyond a reasonable doubt, I don't have to put anything on. I don't have to have my defendant testify. And he didn't testify. consistent with my advice, we don't have any burden. And think about what needs to be proven. Think about what the burden, what the evidence was. Now, there's many things here that happened which are probably the most serious of anything that the state is relying on Melinda Rogers' testimony. That's it. Just like false in one, false in all, you determine the credibility. Did it happen or not? Government has the burden. I don't have the burden of disproving it. I can point out things and there's no probable cause. Excuse me. I can point out things which, in my opinion, don't make sense. Which there is no corroboration. Which there is an alternative view or theory as to what happened. But I don't need to do anything because the government has that heavy burden. Now, as I said, the easy ones are evading a police officer. Yeah, he did it. Next one, impersonating a police officer by the terms of that instruction, which is the law of this state. He didn't do that. Next one is the sexual assault. Did it happen? I wasn't there. But the evidence is she willingly advertised on Craigslist, she role-played, she went with the defendant, and she came back within 5 minutes. Did it really happen? That's up to you. That's your decision. But when we talk about kidnapping, and once again, kidnapping means taking someone against their will. Can't kidnap the willing. Hey, I'm going to put you in handcuffs and take you somewhere. Okay, no problem. And then she goes. And they do whatever. And then she comes back. That's not kidnapping. But if he takes her and she doesn't want to go, that's kidnapping. But when it comes to kidnapping, you have a choice. Is it first-degree kidnapping? Is it second-degree kidnapping? And there's an instruction. For the purpose of, and it's kidnapping instruction, it's number 10. And it talks about first-degree kidnapping and what it is. And it says, every person who willfully seizes, confines, inveigles, entices, decoys, abducts, conceals, kidnaps, or carries away any person by any means whatsoever with the intent to hold or detain or holds and detains a person for the purpose of committing sexual assault is guilty of kidnapping. And that's why it's so important to determine whether or not a sexual assault took place. Because if a sexual assault didn't take place, even if you believe that there was kidnapping, that doesn't mean it's first-degree kidnapping. That means it must be second-degree kidnapping. Judge talked about your oath as jurors. You are the finders of fact. Doesn't matter what I think happened, doesn't matter what they think happened, doesn't even matter what the judge thought happened. It matters what you thought happened. There's a judge in federal court, Judge George, who always says that jury service is the highest form of civic duty except for armed combat in wartime. So this is what you need to do. I'm sure you're all going to take it seriously. I know that. And then the question is, well, how do you decide? You'll go back in the jury room and determine what to do. You will select a foreperson. And there's many ways you can determine what happened. You can take a vote. You can take a secret vote. You can discuss each and every charge. And you can do it any way you want. From the most serious down, kidnapping, or if you believe, as I do, that it's easier, that the decision itself is easier on the evading police officer, which there's no debate. He did it. Then the impersonating of an officer, which according to the instructions, according to the law, did not happen. Then there's the sexual assault, which is more difficult. You have facts which maybe would say that sexual assault took place. Maybe would say that there was sexual conduct that took place that may have been willing. And then you determine that. And if you determine that there was no sexual assault, then when it comes to kidnapping, and you determine that there was a kidnapping that took place, then it must be second degree. Now, our form of jurisprudence comes from English common law. And while it's flawed, I believe it's the best in the world. And from English common law, the first court in England is called Old Bailey. It's a big, huge, majestic court. And in front of that court is this huge rock. And what it says is, the crown never loses. And what that means is, whether you find the defendant guilty or not guilty, whether you find him guilty on some count or not guilty on other counts, the crown never loses. Which means that the district attorney's office and the state does not lose if you find someone not guilty, as long as he or she has been tried fairly. So, ladies and gentlemen of the jury, you should find him guilty of the evading of police officer, but he is not guilty of